Hello and welcome. And tonight's pro line balls discussion is really the hot topic across all of college athletics. And that has to do with Friday evening, June 6th, approximately 9 p.m. Eastern time. Judge Wilkin out in greater Oakland area kind of put her stamp of approval that sets into motion the NCAA Division I settlement. And rather than going round and round and trying to have my interpretation, I thought we would go to a source. We kind of interacted via X, formerly known as Twitter. Philip Sheng is a partner at Venable Law Practice, and he deals with sports law. And the interesting dynamic here, Philip, is that you're a former Division I athlete at Stanford. This is a process that I think you've probably been kind of really delving deep into and have more knowledge, obviously, than myself, but you have a really elite perspective, not only from a legal perspective, but as a student athlete, former student athlete. And I want to get started with this process. I had put something out on X with regard to the designation of DSA, designated student athlete. Wondering if you could break that acronym down and a little bit what it means, not only to current Division I athletes, but also those that graduated high school in 25 with a letter of intent that was signed to play a sport at a Division I school. I was wondering if we could start there.
Absolutely. And first, Coach, thanks for having me. It's a pleasure to be here. So the DSA stands for Designated Student Athlete. It was a very late add to the House settlement, so it was never in there until really the 11th hour. So originally, I'm sure a lot of your followers know this, that originally there were these roster limits that were proposed, and they were set to go in immediately upon approval of the settlement agreement. And what you ended up happening was a lot of students, a lot of parents wrote to the judge explaining that the settlement, if approved, would end their careers essentially because of the roster limit provisions. Coaches were cutting players. Coaches were telling players that if this House settlement is approved, you're going to lose your roster spot. Coaches were telling players to hit the portal. The judge was receptive to these objections, to these complaints, asked the parties to go back and sort of fix the issue. And so how they ended up fixing it, and I say fixing it loosely, I personally don't believe that it really fixed the issue. I still believe that there is a lot of harm that was caused to student athletes. But, we are where we are. And so what the judge's order, or what the parties have agreed to, is that any student who was on a roster in the 2024 to 2025 season, or is an incoming recruit for 2025 who was assured by an institutional staff member, basically a coach. If you're a 2025 recruit and you were assured a spot for the upcoming season, and you were at risk, or you were cut, or at risk of being cut due to roster limits, the school can designate you, or they're required to designate you. They're required to use what the settlement says, good faith efforts, to identify and designate all those student athletes who fit in that category. And they have to provide the lawyers in the House case with a list, their list. Each school that's opted into the settlement has to provide their list to the lawyers by July 6th. I mentioned that the provision was added really late in the game. I don't think much thought was given into it. If you follow me on X, I've sort of pointed out some of the questions that surround the issue. There are a lot of student athletes out there wondering, do I qualify? And my advice to you would be, get on the phone with your coach as soon as possible. Maybe give them a few days, because I'm sure they're talking with their lawyers right now. There's a big conference in Orlando where all the ADs are meeting right now. And I've been told that, this DSA issue is something that's going to be discussed. It's certainly being discussed at the conference level. You might see conferences come together and decide, on the same approach to DSAs. Hey, do we keep everybody on the team as a matter of fairness? Do we, I don't know what's going to happen, but my advice to you guys is get on the phones with your coaches and your schools right away, because it's up to the school. each school is responsible for designating student athletes. So if you don't end up on that list, your only recourse is to call the lawyers in the House case. The lawyers in the House case were given the exclusive right, so to speak, to bring these disputes before the judge. And so I posted on my Twitter the definitions of who qualifies for a DSA status. There's a lot of questions surrounding that still. Happy to go through those if
Absolutely.
those
That is exactly, I think, where parents and athletes really want to know, does this definition of DSA apply to me? Is it applicable to my student athlete or prospective student athlete if they were a high school graduate?
Yeah. So I think there's a threshold requirement that the school that you were attending or that you were planning on attending, there's a threshold requirement that school opt in to the settlement.
Right.
So, there's some schools that have announced they don't plan to opt in until 2026 or 2027. They sort of want to do a wait and see approach to see what happens. I don't believe that those schools qualify to designate students. If they don't opt in, the deadline is in 1 week. I think they've got a deadline of June 15th. Schools have a deadline to opt into this settlement agreement. If your school did not opt in, roster limits don't apply to them. So
Right.
if roster limits don't apply to them, it's hard to say that any of their athletes were affected by roster limits, right? So that's sort of a threshold requirement. Make sure your school has opted into the settlement. I mentioned questions surrounding, who gets to qualify. So there's two, off the top of my head, there's two provisions. The first one applies to current student athletes. Like if you're currently at a school, or if you were on a roster in the 2024 to 2025 season, and you were cut, you certainly qualify or should be put on the DSA list. I'm being told that there's a lot of student athletes who, during the summer prior to 2024 starting, they were in summer camp, or they were whatever, spring practice, or whatever it is, whatever sport, your sport is, whatever they do during the off season. I've been told that there were athletes who showed up to those practices before school started and were cut before the school started. So they were never officially on the roster. Like if you go on Google and you look up a school's roster, you might not see a student athlete, right? So there's some questions there, some ambiguity there, whether or not, look, if you were not officially on the roster or on the official roster, do you count? I sure hope so. Look, if you were, eligible to practice and you were invited to spring or fall practice before the season actually started, and they cut you before the roster was published, I absolutely think that you should qualify. And that's going to be an issue that, for folks who fall in that bucket, closely watch that. Make sure your school's going to add you on that list. There's no penalty for schools over designating, which is interesting. Okay, so the settlement agreement as written says that schools need to, in good faith, create these lists, use good faith efforts. Okay, so there's no penalty, there's no enforcement mechanism for over designating. Like if a school's just not sure, right? If the school, says, hey, golly, I've got 130 people on my football team and I got to cut down to 105. How do I know who the 25 I was going to cut? So, could have been any one of this group right here. So schools, in my view, should be over designating. If there's a question, obviously you're not going to designate the star football player, the star quarterback that you just, agreed to pay millions of dollars. You're not going to cut him, right? But anybody on the bubble, I'm hopeful that schools will over designate, because there's no penalty. There's no, they're not going to get punished for over designating. I don't think, at least. So if you're sort of in that camp, right, call your school. Make sure get their confirmation that you're put on this list. After the schools send the list on July 6th, it doesn't say how this is going to happen, but the lawyers they have said they will make that list available to students. They have said that they're going to keep the list confidential. They don't want, if a player was cut, maybe that's sensitive to them, they don't want, that list floating around there. So it's supposed to be confidential. But I don't know how they're going to make that list available. They said they will, but you will want to, if you student athletes, you want to check with your school, get confirmation you're going to be put on that list. Then whatever mechanism the lawyers provide, you will want to check with them to make sure you're on that list as well. Let me go to another ambiguity in the settlement agreement as to who qualifies for the DSA status. So we talked about current students who are cut before being put on a roster. That's up in the air. The other situation, what's interesting is, they added a protection for incoming 2025s, class of 2025. There is some language in that definition. You can check my Twitter. You can see exactly what the word says. There's the words initial enrollee. You need to be an initial enrollee of a school. What does that mean? Does it mean that you had to actually enroll at the school? Does it mean that you have to, have accepted your admissions, accepted, your spot there? I don't know. I could see arguments going both ways, because I suspect there's a lot of your viewers who, were, had a verbal offer or even a written offer, accepted
Right.
an offer, and prior to, the official time to sign whatever was cut, right? Well, at that point, if you're cut before, any formal decision had to be made about enrolling at a school, I bet a lot of students are like, well, why would I enroll at the school that just cut me, right? So there's this question now whether or not that language, initial enrollee, would require that, a student to actually have enrolled at the school, in order to qualify as a DSA. I can see arguments both ways, for why you would want to do that, and that's, we could probably talk a long time about that, but, that's sort of up in the air. And again, if you are one of those students who, prior to, signing something, or prior to, enrolling officially at the school, you were cut and you decided, hey, I'm not going to enroll there, right? They don't want me. I'm not going to enroll, which makes total sense. You still want to reach out to your school and say, hey, are you going to put me on that list? And it's important, folks, to be put on that list, even if you're, look, and I'll say this too, okay? There are, athletes who were cut because of roster limits who have since transferred and found new homes. And that's great for you guys, very, very happy for you, because it's, a lot of kids are being left, without homes. If you were able to find a home, it is still worth calling your old school and getting, put on that list. It benefits your current team, and it benefits for you. If you have eligibility still left, you absolutely want that flexibility, because, when you're on the transfer portal and it's between you and somebody else, and you have the DSA status and, another person doesn't, your value, your stock goes up, I think, dramatically.
Well, and on that topic, so that, to me, that's a really good, firm understanding of the designation of the DSA athlete, and why it behooves families and student athletes to be in contact with those schools to make sure that, A, you're on that list and been given that designation. The next question, follow-up wise, what would prohibit any school that opts in to the collective settlement why wouldn't they want to stockpile? Let's say, using baseball as a for instance, 34 roster cap, but in theory, I could grab 6 pitchers if I were so inclined that are designated under the DSA title, and I can have my roster at 40 if my school or my conference is allowing that to happen. That, in theory, could happen, correct?
Absolutely, and I expect it to happen. I mean, look, so Notre Dame announced a
Right.
couple weeks
Yep.
ago that it's going to honor all the roster spots for everybody. Okay, does that mean that they will designate everybody, as DSAs? They certainly could, or are they going to go through the exercise of actually figuring out, okay, this person was going to be cut, this person was on the bubble. The easy thing to do would just be to designate everybody. And as I mentioned earlier, there's no enforcement mechanism. There's no penalty for a school. As written in the settlement agreement, there's nothing like, hey, the judge is going to, rip into you if you over designate. It just has to be done in good faith. So, look, does good faith mean you can go and designate everybody? Probably not. But, certainly if there's any question, I would encourage schools, coaches out there to over designate, help your kids out, help your athletes out. The question, the concern you identified, could schools stockpile by over designating their current
Right.
roster? They certainly could, but nothing's preventing them from designating nobody and then pulling 10 pitchers from the portal who are DSAs, right?
Right.
I think the smart thing to do would be to designate, err on the side of over designating. And if schools, every school that opts in they can stockpile. They can grandfather their own players in. If they don't want to do that, that's, I think their prerogative. Does it put them at a disadvantage? They can they can weigh the benefits of having a leaner roster versus compared to budget. Whatever the reason they want a leaner roster, they might want to do that. But I certainly expect coaches and schools to want to stockpile in sports where injuries or pitchers, right? Having many pitchers, right, provides a competitive advantage. And I mentioned earlier, the conferences are meeting and all the ADs are meeting. I suspect that they are going to try to implement some sort of standards by which, schools can't do this. But as far as concerns from the judge or violating a court order, there's nothing in the court order preventing schools from over designating. And I hope it happens.
Well, my next question then would be, in theory, I don't believe it behooves athletes, maybe if they want to validate, hey, I'm at Stanford, I'm at Vanderbilt, I'm at school X, and because really the stockpile athlete, may or may not get playing opportunities, which is a whole different discussion. But I would love, from your perspective, at the end of the day, these rosters, isn't there a true Title IX concern if I start to take your football rosters, your baseball rosters, and I'm using those two sports because they generally have larger rosters and scholarships. If we get into the deeper dynamic of schools can give up to 34 scholarships now with pertaining to baseball, but there has to be, from a feasibility perspective, all of these athletic departments are now paying all of their student athletes if you've opted in with the revenue sharing. But conversely, there has to be a Title IX consideration or foundational basis when you start to say, okay, you have a roster of each athletic department is going to have to go up and down their sports, particularly in the Big Ten, where you have a lot of winter sports that are male and female, men's, women's. Isn't the Title IX component going to come into play with regard to Division I athletics moving forward with regard to roster sizes?
Yeah. I mean, Title IX is a great question. So Title IX, so far, everyone's been talking about Title IX with respect to the revenue sharing. Like, does that have to be equal or proportionate? Do you have to share equally or proportionately with between male and female athletes? That's been the hot topic. But your question is actually very insightful in the sense that, what isn't talked about so much is how the roster limits, affects Title IX compliance. Because if you are going to, grandfather or designate, your entire football team, right? You're 130 right now. We're designating everybody 130, and baseball as well. You start running into a problem where you're going to have much more opportunities for male athletes compared to females, right? So no one's really talked about that. I know it is an issue because when Judge Wilkin originally, and this is in the House settlement, the judge presiding over the case originally said, look, schools, we need to help these athletes who are going to be cut. You guys, you need to do something. You need to provide some sort of solution. And one of the concerns that were coming from schools was like, okay, well, if we have to do this, Judge, we're going to have Title IX is going to be an issue because we've already planned, we've already sat, in front of with our spreadsheets and just, made sure we're in compliance. Now, Judge, if you're telling us that we need to, it's mandatory that we keep all these, kids on our rosters, there's going to be a problem. What ended up happening is that the judge said it was optional, right? So like you can designate a student, but you don't have to keep them on the roster, right? So, so each school is going to need to make a decision, and budget, Title IX, just all these considerations, revenue sharing, right? Do we keep these students on? So the Title IX issue will definitely be at play. So in theory, in the abstract, if you're going to DSA or keep, if you're actually going to DSA, designating doesn't do anything. Designating and keeping the students, that's where Title IX is going to be an issue. Like if you're going to designate and then keep these players on your roster, Title IX says that you need to make the opportunities proportionate, for between male and female. So it's going to be difficult to designate and keep a lot of male athletes and not for females.
Well, I have so many parents that will push back at me and say, geez, this has nothing to do with Title IX. And I keep trying to get parents to really do a deeper dive. And nobody knows more about this than obviously you. You've been on this settlement, the whole from the creation probably all the way up and through Friday, the 6th. And I know a lot of parents are now concerned with, as we move forward and as these conferences begin to, I guess we're going to call it self-regulate from a P4, current P4 as currently constituted. Doesn't this open the door for a lot of hands in the, boosters and the other funding sources that come forward for the P4s? It's almost as if now free agency A is a yearly kind of dynamic. And then also conversely, the contact rules, like the P4 schools now are almost like they're cannibalizing each other. They're going after each other's. At what point does the NCAA say to the Power Four, okay, you guys go be a professional, you guys go do your own gig, and then everybody else is going to be in the Olympic college dynamic that we've all known for decades? At what point does this become part of the new future with regard to college athletics?
Yeah, I personally don't see the P4. I mean, look, it would probably be with specific sports, right? It would be like football breaking off into its own thing. I don't see like, the P4 schools leaving like sports altogether and doing their own thing. I think I don't see that being a possibility. What has been thrown around on the discussion table is having football just be its own thing, and having football actually not even be associated with the NCAA. Have it almost be like a professional league that you mentioned, where those teams can license the school's names and be a part of a school, be affiliated with a school, but it's run entirely outside of the schools, and that gets the schools, out of the Title IX stuff, out of the schools, being managed by schools. It's completely separate. It's like a pro team affiliated with a school that they license a school. You can have the Auburn Tigers, right? As an example that I heard thrown around this morning. Gosh, I don't expect that the P4 will go and do its own thing like on a sport-wide basis. It's going to be just with football. That's what there have been some proposals out there. I don't see it materializing, to be honest with you. Too complicated. Too much money's at stake.
Right. And so with regard to money, how much of the name, image, and likeness pie in reality is now going to be a part of all NCAA levels? Or is it just going, because I get parents that ask me, well, I'm at the Division II level. Can I go do name, image, and likeness? I'm a Division III tennis player. Can I go get my own name, image, and likeness? When it comes to name, image, and likeness specifically within the NCAA, is this a NCAA issue or an NCAA Division I issue?
So there's nothing prohibiting a D2, D3 athlete from striking NIL deals. The House settlement only applies to D1 schools that opted into the settlement. So that the whole concept of revenue sharing, schools being able to pay their athletes up to $20.5 million, that only applies to the D1 level. There's nothing preventing, I would obviously encourage, D2, D3 athletes, just because you're, D2, D3 level doesn't mean that you have a name, image, and likeness that you can't, market and leverage. So, especially with your local communities, your local fan bases, take advantage of whatever opportunities you can. There is no, enforcement mechanism like, for D1, with the revenue sharing, there's a new requirement now that any deal over $600 with a collective, any deals with a collective need to go through this clearinghouse. D2, D3, you are free to go and do what you want to do.
And I guess my final question on that would be, you as a student athlete, you can also be compensated outside your university or college, meaning the college or university at the Division I level is going to have some form of stipend or payment that is allocated per athlete or per sport, what have you. But on the outside, which is something that you deal with, those athletes, are they going to be self-reporting? Hey, this car dealership is giving me a car, and how does that going to work moving forward for the student athlete?
Yeah. So schools at the D1 level who opt in will be able to share $20.5 million and it's at their discretion who to share it with and what sports to share it with. Recently, or as we saw in the House case, the majority of that revenue sharing is going to go towards football, men's basketball. So football, it's going to be about 85% is the number being thrown around. 80 to 85% of that 20.5 million is going to go to football. Another 10 to 15% is going to go to men's basketball. 5% is going to go to women's basketball. And I know those are ranges, so they don't add up to 100 quite yet. But there's going to be just a few percent left over to the rest of the sports, and the schools are free to distribute that how they want. So what you end up having is about 90 to 95% of revenue sharing is going to go towards 20% of athletes. Just going to go to the football players, basketball players, women's basketball players. They have so that's just the schools revenue sharing. Every athlete, no matter what sport, can go out and find their own deals, but any deal over $600 needs to be reported to the NCAA through their clearinghouse. It's run by Deloitte. It's my understanding is it's just like a website. You go fill out some forms. It's a self-reporting mechanism there, and every deal over $600 is going to be run through these algorithms, and it's going to spit out a thumbs up or a thumbs down whether or not that deal is within the range of what they consider, what Deloitte considers fair market. And as long as you get the thumbs up, then that deal you can move forward with it. And if you get the thumbs down, you can still move forward with it too. But you're going to have the NCAA asking you, hey, what's going on here? Tell us more. And if they find out that you accepted a deal that got the thumbs down and it's not fair market value, you risk losing eligibility. And that's the current scheme in place. So that applies to everybody. So every athlete, D1, if your school's opted in, you've got to report. Actually, I'm not even sure I think the requirements, even if your school didn't opt in, I think you've got to report the $600. I'm not sure on that, but anyways, yeah.
So in closing, what would you recommend to any athlete that feels they are affected in some capacity? What should be their process? Is it, kind of break that down to them if you can in like a bullet point? Contact your school, current school, if you're a current Division I athlete. If you're a high school athlete, contact your, coaching resource within your sport. Can you kind of just say, here's what you should do if you feel that this settlement affects you?
Yeah, so I assume you're talking mostly about the DSA status.
DSA, yes.
And what I would suggest to folks is get first collect whatever text messages, emails, whatever you have. I think those are going to be important. I think if obviously if you have a text message chain with the coach who says, hey, I'm sorry we had to cut you because of roster limits, becomes a lot easier to make your case. The tricky part is, if you were told verbally, or maybe you have a text message chain that says, hey, due to roster limits plus budget plus, whatever reasons, those will get tricky too, right? Because a school could say, hey, you weren't cut for roster limits, you were cut for another reason, right? So the first thing I would do is get whatever emails, documents you have, reach out to, your contact at the school. Coach or an assistant coach. Hopefully they're still there. I mean, with turnover, with coaches, it gets a little tricky. But reach out to the coaches, sort of explain, hey, I heard there's this thing going on with the DSA status, and I was, made an offer by so and so, and here's the text message, or here's the info, and I was told that I wouldn't have my spot anymore. Could you please, obviously one. Look, if you want to go to the school, you should say, look, I won't count against your roster cap. Can I still come? Right. And the coach and the team will make their own decision based on, it's not just, look, I mean, we talked about it earlier. There's a lot of other factors that schools need to consider, right? There's budget, Title IX issues. But if you want to go to that school, if you feel the bridge isn't burned, when they cut you, if you still have a good relationship, it's your dream school, I would definitely ask the coach, hey, I won't count against your roster limit now. I'm going to come out there. I'm going to bust it. I'm going to, even if I don't start, even if I, sit on the bench, I will be, I will contribute and I will, bring value to your program. I think that's what coaches will want to hear. Get confirmation that if they say, hey, look, we just can't bring you back on, get confirmation that they're going to put you on that DSA list. and then just sort of hang tight, because at some point, the lawyers have said they're going to make that list available to students. So there's going to be a point where you're going to need to confirm you're on that list, and once you confirm you're on that list, I mean, start picking up the phone. I think you're, as long as you're somewhat competitive, look, you're not, you might not be the star, you might not, be a starter, but look, if you can contribute, I suspect there's going to be a coach out there that is willing to take you on. So that advice would sort of apply to both incoming, 2025s as well as current athletes. Get your documents together, make some phone calls, make sure you're on that list, and then, start calling coaches, reach out to folks like you, reach out to any contacts you have, see if folks out there can help you land on a team.
And we're going to get a lot of parents that are going to say, should I reach out to Philip? Is Philip the kind of guy? So, obviously with regard to today's world, social media, we're going to have all that in our description, both with regard to the podcast as well as YouTube. Anytime we do anything on X or Instagram, et cetera, we'll have all of Philip. But how would you prefer to be contacted peripherally if somebody is trying to get an explanation, or how you can possibly work with a family or a student athlete?
Yeah, feel free to reach out to me on X, on Twitter. I can't provide you direct legal advice. I can sort of give you, my views, my opinions, of course. Feel free to post on my comments, and I'll respond to them on my public page. That way the community might be able to benefit from, any questions you have. Obviously, if there's, sensitive information, specific to your athlete that you don't want out there, send me a private message, a direct message. I'm happy to chat with you and offer just sort of my general thoughts on your situation. But I'm really passionate about this roster limit thing. I feel like there's a lot of students that got the short end of the stick on the settlement agreement. I feel I sympathize with all you parents and kids out there whose students are were affected by the roster limits change.
Well, I want to let parents know specifically that I think it's important that you understand, when we're looking at the X, it's the real, and I want to just spell it for you, SHENGER. Okay. And I really want to stress to parents, yes, Philip is an attorney, but also, again, remember, a former Division I athlete at then the Pac-12 at Stanford, now ACC. So there's some perspective here that really, I think, allows Philip to have a unique opinion, educated opinion with regard to this. And I really feel that at this point, to have someone at least be able to explain to you in a generic layman's terms, Philip's going to have a perspective of a student athlete from a legal perspective that I think can help parents. Philip, thank you so much. I really appreciate you taking the time, because this is a topic that's red hot, and I really wanted to get some clarity that you were able to share with us today.
Absolutely. Thanks for having me, Coach.